In the previous videos, we've been talking about the circumstances in which equity will allow the transfer of legal title to occur, even though the formality requirements have not been complied with. And we've looked at 4 distinct cases where this will happen, and we're now going to look at a 5th case where equity will step in. So we've looked at situations where there's been conveyance of land to a minor, gifts made in contemplation of death, failure to make an effective gift, so that's the every effort rule, and the rule in Strong and Bird. And this is the 5th circumstance where equity will step in. That is where the donor is also a trustee. And we're really going to focus solely on this case of Choithram and Pagarini from 2001. Okay, so let's get started. So Pagarini, who's referred to as TCP in this case, was a wealthy businessman and philanthropist. He had made provisions for his children and family during his lifetime. He wanted to give the remainder of his wealth to a charitable trust. A deed of trust was prepared, naming 9 trustees, including Pagarini himself. Okay, so he wished to establish a charitable foundation by deed, to which he would leave his wealth. And this is another case where the Court of Equity completed an ineffective transfer. So this is what we've been talking about for the last few videos. And it has some sort of similarities to Strong and Bird, which I talked about in the previous video. And just to reiterate, TCP, Pagarini in other words, so TCP is Pagarini. TCP was a wealthy businessman and philanthropist. He owned a chain of supermarkets and gave a lot of money to charity, set up a number of charitable ventures during his life. He had provided financially for his wife and children already. As far as he was concerned, they were settled and there was nothing further for them to have. However, he wanted to give everything else he owned to charity so that when he died, he would be penniless. So he set up a charitable foundation, or rather his lawyers did, by creating a deed of trust. The deed of trust set up a charitable foundation called the Foundation, and appointed 7 trustees as trustees of that foundation, of the foundation itself. One of those trustees was TCP. Pagarini did not sign the deed for some time. In 1992, at a time when he was confined to bed by his terminal illness, his solicitors took the deed to be executed by him. Pagarini signed the deed, then orally directed his accountant, who was present at the signing, to transfer all his wealth to the trust. The witnesses were in substantial agreement that the words used were that Pagarini was giving his wealth to the trust. So let's explain this another way. He was given the deed and asked whether he wanted to sign it, but did not execute the deed. So he didn't sign it in front of witness, etc., until 1992. In 1992, he was very ill and confined to his bed due to his terminal illness. He called his solicitors and they brought the deed to him, where he signed it. The deed of trust was there properly signed and witnessed. So the trust was created at this point, but that was all it did, okay? It did not transfer any wealth into the trust. All it did was establish this framework as a kind of shell ready to receive his property. It wasn't a deed vesting the property in the trustees. Property still belonged to him. He then orally directed his accountant to transfer all of his wealth to the trust. So in other words, that's words of gift. And as we've seen previously, words of gift are not effective to make a gift unless there is delivery of chattels. So it was not a donatio mortis causa, even though he was on his deathbed, because it wasn't a conditional gift. In other words, it wasn't a gift that would be made when he died. It was to be made there and then. Okay, and I've got a video on donatio mortis causa in a previous video, so go check that one out if you can't remember what that is. Now, various documents, including declarations that Pagarini held all his property on trust for the trustees of the charitable foundation, were prepared for Pagarini to sign, but he did not do so before his death about a month later. So the accountant noted that TCP didn't have long to live, that's Pagarini again, didn't have long to live, and urgently prepared all the transfer forms for TCP to sign to transfer legal title. But once the transfer form were given to TCP, he refused to sign them. He seemed to have lost interest in saying he had already. He seemed to have lost interest, and he seemed to believe that he had already disposed of his property. And he died about a month later, and so prima facie, this does look like an incomplete gift. Now, the issue was whether by his oral declaration, Pagarini had successfully transferred the property to the trust. Now, as already said, it was an oral declaration, and as we know, oral declarations do nothing, okay? Until the formality requirements of a gift are complete, an oral declaration on its own will give someone that you want to give something to someone is going to be completely ineffective. So the issue was whether in the circumstances TCP had managed through the oral declaration to transfer the property to the trust. Okay, so that's really what the court was dealing with here. And at trial, it was held that there were two methods of transferring property: by effective transfer of the legal title or by declaration of trust. In this case, there had been no transfer of legal title in the shares and other property. The words used by Pagarini were words of gift, not words of trust. Accordingly, the property was not transferred to the trust and fell into Pagarini's estate. So at trial, it was held that there were two methods of transferring property, as I just said, either effectively transferring the legal title, and this didn't apply as he hadn't complied with the legal formalities to transfer his property, or by a declaration of trust, by declaring yourself to be a trustee for the benefit of the recipient. If neither of those had taken effect, then there is no transfer of the title. And it was held here that the words used by TCP were words of gift and not trust, and accordingly, the property was not transferred to the charitable trust but went to his estate. So as a result, the property went to the beneficiaries under the rules of intestacy, because as far as he was concerned, there was no reason to leave a will because he had nothing to leave. Okay? So he didn't create a will, so it got left under the rules of intestacy because he wanted to be penniless when he died. But the Privy Council allowed an appeal, and although this seemed to be a case of an incomplete gift in which the principles in Milroy and Lord would apply, that is, equity would not perfect an imperfect gift, subject to the every effort rule in these two cases of Rose that we saw previously, the case involved unusual facts. In particular, Pagarini was a trustee of the trust to which he was giving the property. So the Privy Council allowed an appeal. They held it was an ineffective transfer of equitable title, and this was an unusual case in that TCP was a trustee of the foundation. In his own right, he was legal owner of the property. The intention was the property would vest in the trustees of whom TCP was already one. Okay? So if someone holds property as a trustee, they don't need to transfer legal title because they already have it. Okay? And as Lord Brown Wilkinson actually says in this case, although equity will not aid a volunteer, it will not strive officiously to defeat a gift. Okay? And he also says the following: although the words used by TCP are those normally appropriate to an outright gift, I give to X, in the present context there is no breach of the principle in Milroy and Lord if the words of TCP's gift, i.e. to the foundation, are given their only possible meaning in this context. The foundation has no legal existence apart from the trust declared by the foundation trust deed. Therefore, the words I give to the foundation can only mean I give to the trustees of the foundation trust deed to be held by them on the trust of the foundation trust deed. Although the words are apparently the words of outright gift, they are essentially words of gift of trust, on trust. Okay, so the only way the foundation could actually hold the property would be as beneficiaries, because there are 7 trustees existing to hold the legal title. So saying that you will give property to the foundation, which looks like a gift, i.e. a transfer of absolute ownership, can only involve the transfer of equitable ownership to the foundation, as the trustees are the ones that retain the legal title. Therefore, what looks like a gift to the foundation is actually translated as giving the property to the trustees to hold the property on trust for the foundation. So if you give to a trust, you are technically giving to the trustees of the trust to hold on trust for the beneficiaries. And this is what Lord Brown Wilkinson is saying. If you give to a charity, this is the only way they can hold property. The trustees hold the property for the charity's benefit. So although it looks like words of trust, they're actually creating a gift on trust. Okay? Now, there can in principle be no distinction between the case where the donor declares himself to be sole trustee for a donee or a purpose, and the case where he declares himself to be one of the trustees for that donee or purpose. In both cases, his conscience is affected, and it would be unconscionable and contrary to the principles of equity to allow such a donor to resile from his gift. So, whether a donor is a sole trustee or part of a group of trustees, there is no distinction to be made. So what this means is that because he is giving the property to the trustees and he is one of those trustees, he is giving the property to himself as one of those trustees to hold on trust for the foundation. So although it looks like a word of gift on its true construction, it can have no meaning other than that of words of trust. And it is important that there are 6 other trustees, because if someone receives property as a trustee, their conscience is bound and they are bound to hold the property on the terms of the trust. So once TCP declares he is giving his property to himself as one of the trustees to hold on trust for the foundation, that is a declaration of trust, and once he has made that declaration of trust, his conscience is engaged, and it would be unconscionable for him to try and change his mind or go back on that gift. Say, in the present case, that TCP had survived and tried to change his mind by denying the gift. In their lordship's view, it is impossible to believe that he could validly deny that he was a trustee for the purposes of the foundation in the light of all the steps that he had taken to assert that position and to assert his trusteeship. So, in other words, by creating the trust and appointing himself as a trustee of the foundation, and by giving to the trustees of the foundation of whom he was one to hold on trust, he was effectively binding himself by the trust, and he would not have been able to change his mind. So it was a valid transfer of property. The transfer was upheld, but only in the particular circumstance where someone is a trustee and gives to the trust. Then words of gift on their true construction be words of trust. So this is not a common scenario at all, and that's why I wanted to talk about this particular case as the final of my 5 particular circumstances where equity will actually step in to allow the transfer of legal title to occur, even though the formality requirements for doing so have not been complied with. Okay, so that probably wraps up this particular video and the 5 circumstances where equity is going to step in. In the next video, I'm going to start talking about the rule against perpetuities, which can also cause some problems for some people. So if you have any questions about this video, please leave a comment below and I'll get straight back to you. And don't forget to like and subscribe to my channel. Thank you very much for watching.